Fun thought experiment, Liz. What if instead of taking that $130,000, Daniels had actually sold her story to the press? Would Trump have won in 2016?
That's not a fun experiment.
No,
that's the way madness lies. Yeah.
Heard, I got a lot of these that go back to 2000, but anyway.
Welcome to Law and Chaos. It's been a wild night in a lot of courts for Donald Trump. He is, in fact, getting sentenced tomorrow morning, and the Justice Department may be able to release Special Counsel Jack Smith's report eventually, or maybe not. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
Hi, Liz. I'm doing all right. I would like to go one Thursday without, us waiting on 4 different courts to issue opinions at like 8 o'clock at night. But, we're here. We make the sacrifices. We read the law, so you don't have to.
Uh-huh. Indeed. Obviously, we have the Supreme Court's decision and the 11th Circuit's ruling with respect to Donald Trump to discuss today, which we will. But first, let's get to it. It's time for docket alerts. Dun dun. You'll have to. We're still looking for a bumper. I really did try and find one today, but I felt like one of those old ladies that go into the store and be like, "Sonny, can you sell me a thing?" And I didn't even know how to describe it. Like, was it a logo? Is it like a sound effect? It's none of those things. The sound effects are all like breaking glass. The sound of a vampire sucking the blood out of somebody's neck. I'm like, Anyway, we might have to.
You drive through that corset store. They don't mind. Anyway, so many things are going to happen tomorrow. Today, as you're hearing this on Friday, January 10th, right? We have the Donald Trump sentencing at 10 a.m. before Justice Juan Merchan in New York. Donald Trump can appear for that remotely. Will he? Let's find out. The Supreme Court refused to halt that, so that's a good thing. We're going to be talking about that in detail. But speaking of the Supreme Court, did you like that transition? Subtle. They are hearing oral arguments Friday morning on the TikTok ban. And we discussed this in depth in episode 90. Congress passed and President Biden signed a law which will essentially shut down TikTok on January 19th if the platform isn't sold to a U.S. company. And bizarrely, the D.C. Circuit said, sure, as long as the government shouts national security at the top of its lungs and waves its hand around frantically like he can get around strict scrutiny, not a problem.
Yeah, you may infer from Andrew's tone that we do not think that this law passes First Amendment muster at all, and that it's a stupid idea to boot. Anyway, the Supreme Court agreed to extremely expedited briefing just 9 days before the law is scheduled to go into effect. Since then, Trump has filed an amicus brief explaining that the court should refrain from ruling because Artie McDeals will soon be back in the White House and he alone can fix it. You will note that that is not a legal argument, but with the Supreme Court, who knows? I will note that ByteDance, the parent company of TikTok, is already working to get around this by shifting users to other apps it owns, like CapCut and Lemonade, or Lemonade, I think is what it's called. I'm not hip with the kids. I've already said it on the show. It's not like I'm going to preserve my credibility here. But what they have not done is find an American buyer to take this off their hand. And indeed, the Chinese government has made it illegal to export the algorithm that basically is TikTok. So I guess we'll see.
We will see. I am also Steve Buscemi with the hello fellow kids. But anyway, and to burnish my, hipster credentials here, I want to point out that as a fun bit of law geekery, former Solicitor General Noel Francisco will be arguing on behalf of TikTok, and opposite him will be current Solicitor General Elizabeth Prelogar.
And future Solicitor General John Sauer is the one who filed that fakakta brief on behalf of Donald Trump. And by the way, today he is arguing that releasing the special counsel report is illegal because it violates the Presidential Transition Act, which may indicate just how much of a come down we're going to have in the next administration.
Our current Solicitor General is just a rock star. Francisco served in the Trump administration, but look, he was, I realize there's a little bit of grading on a curve here. He was and still is a real serious lawyer, right? Somebody that a company like TikTok might hire to represent themselves in front of the Supreme Court. Like, there will not be people of his intellectual heft in the next Trump administration. Anyway, speaking of Trump, he has made yet another absolutely batshit argument in a defamation case, this one filed by the Central Park Five. We haven't talked about this case previously on the show, but Trump infamously took out an ad in the New York Times back in the 1980s calling for their execution as teenagers. The Central Park Five, Yusuf Salaam, Raymond Santana, Kevin Richardson, Antron Brown, and Corey Wise were essentially coerced into confessing to the assault and rape of a jogger in New York Central Park. They were later exonerated. And flash forward to 2024, during the only presidential debate, Vice President Harris castigated Trump for it correctly. And Trump responded, "They pled guilty." And I said, well, if they pled guilty, they badly hurt a person, killed a person ultimately. And amongst his barrage of lies and they're eating the dogs, and like, the victim was not killed. She survived. Right. So in October of 2024, the 5 exonerated men sued Trump for defamation. Salaam, for example, is now a city council member in New York. And look, like, I don't want to get into the full merits of whether this is a great defamation case, but like, Trump has filed a motion to dismiss, arguing that what he said was substantially true. And I don't know how you can say someone was killed and she's not dead, how that could be substantially true, right? And also, substantial truth is an affirmative defense to defamation. Like, I'm not sure that it belongs in a motion to dismiss, but like, you heard it here first, folks. A crime victim who is living is substantially dead, saith our once and future president.
Oh, my God. Okay, and in North Carolina, the state's highest court has blocked certification of the election of one of their own colleagues. Democrat Allison Riggs beat sitting appeals court judge Jefferson Griffin for a seat on the North Carolina Supreme Court. There have been 2 recounts, which confirmed Riggs's 743 vote win, which is very narrow.
Yeah.
But it's not like 8 votes. Anyway, Griffin is arguing that voters whose citizenship was not verified should have their ballots tossed out. That's like 60,000 votes. To be clear, Griffin is not alleging that a single one of those votes was cast fraudulently or cast by someone who is not a U.S. citizen. He's arguing for pure disenfranchisement as a means of decertifying his electoral loss. Griffin already tried this shit in federal court, and Trump appointee Judge Richard Myers tossed the case. But, I mean, he really tossed it because he said there's no federal legal issue. It's purely an issue of state law. Now, the Republican-led North Carolina Supreme Court has held up the election certification on the theory that people who believed they cast their ballots legally and were treated as if their ballots were legal should maybe be retroactively disenfranchised. It's incredibly dangerous, even if they do ultimately allow the certification to proceed.
Yeah, because this works on multiple levels. I mean, let's highlight what's going on here. Republicans are constantly trying to disenfranchise voters for technicalities, like forgetting to date an absentee ballot or forgetting to initial a page or having the wrong kind of ID or your signature doesn't look the same way it did 12 years ago. None of that is evidence of voter fraud. It's a way to stop people from voting or, in cases like this, to stop their votes from counting. It is fundamentally undemocratic, and courts have almost always agreed that uncounting votes from people who were entitled to vote and cast their ballots in good faith is the worst kind of wrong. And for the first time that I can find, the North Carolina Supreme Court is saying, well, maybe, kind of.
Yeah. And in further horrendous news, a federal judge in Kentucky struck down the Biden administration's efforts to protect trans kids in schools under Title IX. This was a case that was literally about fucking pronouns. I mean, it's not only about pronouns, but the Biden administration wanted to force teachers to use a child's appropriate pronouns. But Judge Danny Reeves, he's a George W. Bush appointee to the Eastern District of Kentucky, does not believe that gender identity protections have anything to do with sex discrimination, which you may note is not what the Supreme Court said in Bostock v. Clayton County. That was the decision authored by Justice Gorsuch with Chief Justice Roberts in agreement that enshrined gender identity protections in employment context. But see, that case, Bostock, dealt with Title VII, which regulates, as we said, employment discrimination. And here's how Judge Reeves squared that circle. As this court and others have explained, expanding the meaning of on the basis of sex to include gender identity turns Title IX on its head. While Title IX sought to level the playing field between men and women, it is rife with exceptions that allow males and females to be separated based on the enduring physical differences between the sexes. For example, institutions that receive federal funds may permit separation of the sexes for purposes of living facilities, boys and girls conferences, and social sororities and fraternities. The department compares these provisions to Title VII's exceptions that permit, quote, discrimination when, quote, religion, sex, or national origin is a bona fide occupational qualification. However, this argument is hardly convincing considering the fundamental difference between Title VII and Title IX. Title VII prohibits discrimination in the workplace generally, and thus the exceptions for bona fide occupational qualification do not have the potential to swallow the entire statute. Conversely, the entire point of Title IX is to prevent discrimination based on sex. Throwing gender identity into the mix eviscerates the statute and renders it largely meaningless.
I don't even know where to begin. I keep thinking, Liz, about your coverage of Texas Attorney General Ken Paxton's troll suit against the NCAA, where he deliberately misgenders all of these female athletes whose bodies produce high levels of testosterone, a condition known as hyperandrogenism. Those women were born and raised as women, but somehow they don't count as women. And Judge Reeves is talking about the enduring physical differences between the sexes as, if everything is permanent and fixed and obvious. I mean, look, these horrible bigots are so fixated on gender at birth, unless the women don't live up to some magical formula, in which case they become men. It's nonsensical and it's awful.
Yeah. Well, none of that is good. But we saved Rudy as a little palate cleanser at the end of Docket Alerts. A soupçon of silliness, mostly for our subscribers. We talked a whole bunch about Rudy getting held in contempt last week in the New York case, but we talked a lot less about the D.C. contempt case, where Rudy will not stop defaming Ruby Freeman and Shay Moss, despite that $148 million judgment. The hearing is next week, the contempt hearing, and Rudy's lawyer, Jonathan Gross, asked the court to let him attend virtually. You may recall that Joey Bada Bing Camerata tried to claim that Rudy could not attend his contempt hearing in New York last week because he has respiratory issues left over from 9/11, and Judge Lyman said, no.
Yeah, look, practitioners typically, don't take legal advice from a podcast or anything, but don't ask the court to accommodate your client's medical issues without attaching a doctor's note or a sworn declaration, something, right? Because otherwise that's not going to go well.
Right. And so once again, Rudy did exactly what you said not to do. His lawyer, Jonathan Gross, filed a motion yesterday asking the court to let Rudy attend the hearing today, as we're recording this, the 10th, Friday. It's a very busy day, January 10th. He asked him to let him attend virtually. Just as an aside, Gross is a Baltimore lawyer. He's from here, where you and I are. He last appeared on this show representing Matt Gaetz. He was not a guest on the show. He was the subject of mockery. It's different.
He's welcome. We'll interview him.
Oh, for sure. But he only was a subject of brief mockery since he represented Gaetz in his motion to stop the House of Representatives from releasing the ethics report. Unfortunately, he filed in the morning that it was going to be released. That was after every reporter in D.C. already had an embargoed copy. Also, there was that pesky speech or debate clause. Anyway, the case which Gross filed lasted less than 12 hours and got dismissed by close of business the day it was filed. And here, Gross is arguing on behalf of Rudy Giuliani that Rudy cannot show up in court because he is the subject of international assassination attempts and also his knees hurt.
Listen, I gotta say, if anything, you're underselling this one. I mean, the man actually said that the Ayatollah wanted to kill him in answer to the question, "Sir, why did you not renew your New York driver's license?"
Yeah, I mean, who among us? Anyway, Gross padded that. Camerata had a one-page letter. Gross padded it out to a 6-page motion. And the court was no more receptive. Judge Beryl Howell said, no, not going to happen. She did say it in a very funny way. We're going to get into it in the Patreon bonus. So if you are a Patreon, listen up because it's going to be a giggle. And if not, we will see you on the other side of this ad break.
And we're back. Okay, Liz, we put it off long enough. Let's talk Trump.
It's already starting to feel like the last time where every freaking news cycle is just like getting pummeled with crazy lawlessness. I mean, like, This time around, Andrew, promise me, if I ever make worshiping a federal prosecutor my entire personality, promise me you will stage an intervention.
You're not going to be wearing a T-shirt that says "Comey is my homie," or
No, I never did that. Although some people on our side may have done those things. Anyway, but I did do some resistance Twitter shit. We're not doing that again. Okay, moving on. As we are well aware, Donald Trump is going pedal to the metal to erase all evidence of his crimes before he gets back to the White House. He wanted the Supreme Court to step in and stop Justice Juan Merchan sentencing him this morning at 10 a.m. for those 34 counts of creating a false business record. And aside from that, he's trying to leverage his two dipshit henchmen, Walt Nauta and Carlos de Oliveira, to ensure that the special counsel report on all of his crimes never sees the light of day. He lost a round on that front today, sort of, maybe. We're going to talk about that in a second. But first, let's talk about Justice Sam Alito.
Yeah, I hear his wife is very fond of the flags. He can't control his wife. He can't control every other woman in America. But
oh, Christ, I know. And quite a few billionaires, too. Okay, so Wednesday morning, ABC reported that Alito had been chit-chatting on the phone with one Donald J. Trump on Tuesday afternoon, which that's kind of record time for a SCOTUS leak. Somebody really wanted to make sure that was known. But Wednesday was the day Trump filed his petition to the Supreme Court to, stave off the Merchan sentencing, just by coincidence. When confronted with the story by ABC, Alito said, William Levi, one of my former law clerks, asked me to take a call from President-elect Trump regarding his qualifications to serve in a government position. I agreed to discuss this matter with President-elect Trump, and he called me yesterday afternoon. We did not discuss the emergency application he filed today, and indeed, I was not even aware at the time of our conversation that such an application would be filed. We also did not discuss any other matter that is pending or might in the future come before the Supreme Court or any past Supreme Court decisions involving the president-elect.
Sure. I'm old enough to remember when Attorney General Loretta Lynch had to withdraw from the Clinton email investigation because she talked about her grandkids with Bill Clinton for 90 seconds on the infamous tarmac. But, she was a Democrat. So also, shut up. ABC says Levi is being considered for various legal jobs in the incoming administration, including general counsel of the Department of Defense. And, don't try and bullshit me that, Trump is running down references for a lawyer at the Department of Defense. Come on. I mean, this is someone who began his conversation with Ukrainian President Zelensky with, I'm happy. I want to talk to you about, having you not get taken over by the Russians, but first you got to do us a favor. Here's a statement from Gabe Roth, our buddy over at Fix the Court. He was also on episode 14 of the show. President-elect Trump, Justice Alito, and Will Levi, who's been a chief counsel in Senate Judiciary and a top DOJ advisor and is the son of a federal judge and grandson of an attorney general, should know better. But they don't care because they know no one in Congress or the judiciary will hold them accountable for ethics violation. If anything, this type of breach in protocol is a badge of honor in Trump world. No one is questioning Levi's credentials, which are as good as can be. The call was merely an excuse for Trump to speak with one of the 9 people determining the fate of his hush money sentencing in the coming days, and who will review many more Trump-related issues over the next 4 years. Typically, Trump and Alito are better at hiding their ethics issues, at least for a few months or sometimes longer. But with the Supreme Court greenlighting near absolute presidential immunity last year, and with Congress refusing to pass enforceable ethics for the justices, it appears there's no reason to even try.
Yep.
Yeah.
Okay, with that as background, let's read the brief order that appeared on the Supreme Court's docket at around 7 o'clock this evening. The application for stay presented to Justice Sotomayor and by her referred to the court is denied for, inter alia, the following reasons. First, the alleged evidentiary violations at President-elect Trump's state court trial can be addressed in the ordinary course on appeal. Second, the burden that sentencing will impose on the president-elect's responsibilities is relatively insubstantial in light of the trial court's stated intent to impose a sentence of unconditional discharge after a brief virtual hearing. Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh would grant the application.
Yeah. So first, Andrew was wrong here, right? One of the things that I said to you as we were waiting for this was that I thought this was going to be a 6-3 decision no matter what, right? Either it would be the 3 liberal justices on the bottom in dissent, or it would be the MAGA loyalist contingent, right? Alito, Gorsuch, and Thomas, and everybody else on top. And we've lost Justice Kavanaugh now to the MAGA loyalist contingent, I think.
I mean, I think that he was always pretty craven in that way. But I think 4 justices, that's bad. 4 justices who would throw out any pretense of propriety and law to do a favor for Donald Trump is, look, it's bad, right?
Yeah.
It's bad. And I'm sure it will reignite the conversation about whether Justice Sotomayor should have retired and let President Biden replace her. I mean, I'm not going to weigh into that. I think that people really do say that about women all the time, that they should go, that they should fall on their swords. But it's not good.
Also, that doesn't get you 2 more votes. But I want to shout you out because somebody I had written off as a potential swing justice because of my background and my views on her background is Justice Amy Coney Barrett. And you identified that. You flagged, for example, that she was the one asking hard questions, far harder than anybody else on her side of the aisle during the Trump v. U.S. immunity hearing. I mean, ultimately, she signed on. I mean, look, again.
No, she didn't sign on to all of it. She didn't sign on to one section of it. But I do think that she is still shameable. I think that most of the other obviously Kavanaugh and Alito and Gorsuch and Thomas are beyond shame. I mean, I think Kavanaugh is basically a weather vane, but I do think Barrett is capable of shame, and this would have been so shameful and craven that she wasn't willing to do it.
Yeah, let's discuss the backstory here. In May of 2024, Trump was convicted of creating all those fake invoices and checks to reimburse Michael Cohen for the hush money payment that he made to Stormy Daniels in 2016 to keep her quiet. Fun thought experiment, Liz. What if instead of taking that $130,000, Daniels had actually sold her story to the press? Would Trump have won in 2016?
That's not a fun experiment.
No,
that's the way madness lies. Yeah,
heard. I got a lot of these that go back to 2000. but anyway, Trump was convicted in May of 2024. Was due to be sentenced in July. He already postponed that hearing 3 times, including in September when he said that it would constitute political interference to sentence him before the election. Then, after he won the election, he said it would constitute political interference to sentence the president-elect. Funny how that works. And Justice Juan Merchan said no. The trial judge rejected Trump's demand to overturn the verdict because it rested on official acts which are immune under Trump v. U.S., and Justice Merchan rejected Trump's demand to overturn the trial based on president-elect immunity, which is not a thing, not even before this Supreme Court. And then Justice Merchan did something really smart. He said, I'm going to sentence you to nothing. I'm not even going to make you show up in person for this hearing. You can attend virtually. So the burden on your presidential transition is pretty much zero, right? Because Trump's lawyers, Todd Blanche and John Sauer, have been making this argument that, it violates the Presidential Transition Act to take up a second of Donald Trump's valuable time, right? Like, here's what they said. The president-elect's complete engagement and undivided attention to this process, the transition process, are critical for national security. During the transitional period, the president-elect must communicate with world leaders, not true, formulate his agenda for foreign and domestic relations, select key personnel for his incoming administration, and coordinate with the outgoing administration across all agencies of the federal government. Indeed, President Trump has been actively engaged in all these tasks since November 5th, subject to the unconstitutional disruption of this state court criminal proceeding. And then Merchan basically did everything he could to zero out that argument, nonsensical though it is, which, as you heard in the Supreme Court's order, seems to have convinced just barely 5 of them that maybe the sentencing wouldn't be such a burden.
Yeah, we're going to come back to this later, particularly when you talk about Ed Meese's brief. But I just want to flag that Trump's lawyers weren't just talking about taking up his time. They said it's illegal to sentence the president-elect because it might make people think bad about him, and that casting aspersions on the president or the president-elect is bad for the country. And look, it's not that far from there to saying it's illegal to criticize Trump, which he's suggested before, actually. Uh-huh. He's suggested locking up his critics. He suggested locking up people who print things he doesn't like. And so I think that it's outrageous and it's also dangerous. But okay, let's deal with the second part of the argument made by the future Solicitor General and the future number 2 at the DOJ. that's John Sauer and Todd Blanche, which is that the president-elect enjoys the same immunity as the sitting president. They said sitting president immunity extends into the brief transition period between which the president-elect prepares to assume the executive power of the United States, and the courts thus lack authority to adjudicate criminal claims against him. Because if it's illegal to sentence a sitting president, it's illegal to sentence the president-elect by this logic, which is nuts. We have one president at a time. And today, that president is Joe Biden. So first, Trump moves for emergency relief from the Intermediate Appellate State Court, which he lost. Then he moved for emergency relief from the New York Court of Appeals, the state's highest court, which denied relief in a 2-sentence order this morning. But simultaneously with that motion to New York's high court, Trump filed an emergency motion to the Supreme Court, specifically to Justice Sotomayor, who presides over New York's emergency petitions. And she ordered DA Alvin Bragg to respond by this morning, which he did.
Yeah, this was a comprehensive brief, and again, it just barely brought along Chief Justice Roberts and Justice Amy Coney Barrett. And I just cannot stress enough how utterly without legal merit Trump's argument was. But, this basically had 6 components. There was no jurisdiction, right? Because the state criminal proceeding is ongoing, right? And courts don't review criminal proceedings that are in the middle. They review them when there's a final judgment, which is what we wanted.
Right. And Trump doesn't want a final judgment. I mean, just to highlight it here, the way that this is supposed to go is that you're supposed to get the final judgment. It's not really final until sentencing is pronounced. I mean, in New York, you're a felon from the time you're convicted. Some jurisdictions, it's not a felon until the sentencing is pronounced. He's a felon under New York law already, but the case can't be appealed really until until the sentencing is over. And so that really jurisdiction shouldn't attach until afterwards.
Yeah. And even if it had, there was a long-standing doctrine, we've talked about it on this show before, called Younger abstention. It stems from Younger versus Harris, a 1971 decision. It basically says federal courts should not interfere in state court proceedings, particularly state court criminal proceedings, right? And lots more reasons, right? Like, as you pointed out, Liz, the delays here are due to Trump seeking 3 separate extensions, right? There's no prejudice. He's not going to be sentenced to anything. And there's strong risk of mooting the case, right? As you point out, everything goes into limbo on the 20th because, you can't continue to proceed against a sitting president. Like, this was it was a really, really well done brief. I'm glad it won, but I'm terrified that it only won 5-4.
Yeah. Well, tomorrow we will see if Donald Trump shows up for this sentencing. I think it's more likely than not that he will not. He will simply defy the court's order, which will not change things. But as we said in the last show, it's defiance of the law, which was one of the things which Chief Justice Roberts cited as, intimidating judges. We shall see. All right. If you are a supporter over at patreon.com/lawandchaospod or at lawandchaospod.com, you're going to hear us break down the amicus brief filed by the criminal former Attorney General Ed Meese. And if not, we will be right back after we pay some bills.
And we're back. Okay, that's the Supreme Court. Now let's talk about the 11th Circuit. And Liz, you and I have tended to treat the 11th Circuit on this show as, the conservative court, but they're the ones that smacked down Judge Aileen Cannon twice. They're our buddies. We're fine. And,
I mean, they're not our buddies, but yeah.
Well, right. And I think we need a little bit more nuance now on what this court is up to.
Yes, the 11th Circuit did rule and did not grant Trump his request to, shit can the entire special counsel's report. But it wasn't good, and I don't think it's over. So, all right, let's begin with what happened. Monday night, as we were recording the show, Trump's henchmen, Walt Nauta and Carlos de Oliveira, raced into Judge Cannon's courtroom in Fort Pierce and demanded an injunction blocking the release of special counsel Jack Smith's final report. That's the report which special counsels transmit to the Attorney General, who then transmits it to Congress and generally makes it public. That is how it's always gone. Biden led the report by special counsel Robert Hur on his own classified documents to be made public. And even Bill Barr published the Mueller report.
I mean, did he?
Yes, look, he lied his ass off about it, right? He set up 2 weeks where he could say, like, this said, he's totally exonerated, and then it came out, and that's not what it said. But he understood that there was no keeping the thing under wraps. But as we said, Donald Trump is not planning to play by any rules, not when he's president and not now. So we all remember in July when Judge Cannon discovered that special counsels are illegal because the attorney general can only appoint someone who's already employed by the Department of Justice for reasons. That's not what the statute says, but whatever. This discovery had escaped notice by anyone ever before, including the multiple federal courts and the D.C. Circuit, which had already ruled on this question. Anyway, Judge Cannon dismissed the documents case, after which she had no jurisdiction over this matter.
Oh, please, Liz. Judge Cannon doesn't need jurisdiction. I mean, this is the judge who decided that she had the right to evaluate the sufficiency of a judicially approved search warrant to search Mar-a-Lago based on magic MAGA beans. I mean, she's not going to let a little thing like jurisdiction stop her, which, look, Trump celebrated this back in July, but it kind of creates a problem now, right? Like, because if you've been dismissed out of the case, then how can you run back to your concierge judge in Fort Pierce, Florida and demand even more than, everything?
Well, so what happened here is that Nauta and De Oliveira are acting as factotums to make these arguments on Trump's behalf, which may or may not have something to do with the fact that Trump's PAC is the one paying their legal bills. So what they did was they filed essentially identical briefs in front of both Judge Cannon and the 11th Circuit, although they asked the appellate court to remand to Judge Cannon so she could deliver the kill shot, but you get the point. So cutting to the chase, Judge Cannon immediately granted the dipshit's motion. She jumped out in front of the 11th Circuit. She did not ask the government for a response. She just gave Trump what he wanted. She said, pending resolution of the emergency motion filed in the 11th Circuit and/or any further direction from the 11th Circuit, Attorney General Garland, the Department of Justice, Special Counsel Smith, all of their officers, agents, and employees, and all persons acting in active concert or participation with such individuals are temporarily enjoined from A, releasing, sharing, or transmitting the final report or any drafts of such report outside the Department of Justice, or B, otherwise releasing, distributing, conveying, or sharing with anyone outside the Department of Justice any information or conclusions in the final report or in drafts thereof. This order remains in effect until 3 days after resolution by the 11th Circuit of the emergency motion, unless the 11th Circuit orders otherwise.
Yeah. Okay, practice tip. I have never seen a trial judge say, I'm entering an injunction, and also I'm taking an extra 3 days on an emergency motion to monkey around with whatever the appellate court does. And I've doubly never seen it when said appellate court has repeatedly smacked you down for not knowing the first goddamn thing about the law. But okay, more to the point. What Judge Cannon is talking about here is keeping the entire special counsel's report under wraps, right? Not just the part about the documents case. She is reaching out from her podunk little Florida courtroom and saying that the election interference case has got to get buried too.
Right. And even though Judge Cannon's order is an order awarding injunctive relief, it's not an order that analyzes the standards for granting that relief. Those like irreparable harm or likelihood of success on the merits or balance of equities. Like, no, she's not engaging with any of that. She just says to preserve the status quo as this court awaits resolution by the 11th Circuit of the similar emergency motion to prevent irreparable harm arising from the circumstances as described in the current record in this emergency posture and to permit an orderly and deliberative sequence of events. And orderly and deliberative sounds like she wants to take her sweet ass time until, say, I don't know, January 21st.
Yeah. And then after that prologue, Judge Cannon just grants the injunction. So, right, as you point out, that's not analysis. And Liz, you wrote a blog post yesterday, lawandchaospod.com, that compared and contrasted Judge Cannon with another character from the Law and Chaos cinematic universe, Judge Matthew Kacsmaryk of the Northern District of Texas, Amarillo Division, right? That's the go-to guy when you are forum shopping some crazy. And when Texas Attorney General Ken Paxton tried to do a similar thing in front of Judge Kacsmaryk, Kacsmaryk told him to get bent, right? So, in other words, the takeaway, we'll link it in the show notes. You should read it. But Liz, I think you make a compelling case that Judge Aileen Cannon is the only Trump judge in the country, either stupid or corrupt enough or both, to have given Trump what he wanted here.
Yeah. I mean, I don't know, considering what happened tonight, but we'll come back to that. So when Judge Cannon dismissed the case, she did not order Smith to stop working or to quit litigating in D.C. or doing whatever. And she couldn't, since Smith is in D.C., where courts have said special counsels are legal. And as I said, Trump's lawyers didn't make this special counsels are unlegal argument in D.C. at all until after Judge Cannon ruled and after the Supreme Court sent the case back, right? After the court's immunity ruling, when it came back, they came to Judge Chutkan in D.C. and said, okay, we know the time to file motions to dismiss is long past, but we'd like to file a motion to dismiss because special counsels are illegal. And Judge Chutkan was like, I don't know, knock yourself out. But I will be following the precedent of the D.C. Circuit, which does not say that special counsels are illegal. I don't think that motion was ever ruled on before the election, after which the case got dismissed. But obviously, the special counsel was not prevented by Judge Cannon's dismissal from continuing to do his job because, Judge Cannon couldn't stop him from doing something, right? So after Cannon files her injunction, Attorney General Garland publishes a letter, which he has sent to the leaders and ranking member of the House and Senate Judiciary Committee, saying that the report has 2 volumes. Volume 1 addresses the election interference case. He intends to make that public as soon as the Cannon kerfuffle is resolved. And Volume 2 is about the documents case, so he's going to make that available just to the leadership of judiciary, and he's going to show it to them in redacted form for in-camera review and after they've agreed not to disseminate the contents. He says, I have determined at the recommendation of the special counsel that Volume 2 should not be made public so long as those defendants' criminal proceedings are ongoing. And that would appear to moot De Oliveira and Nauta's arguments, which we're going to talk about after we come back from one more ad break. And we're back. Okay, so briefly, Trump's henchmen made 3 arguments, 2 of which are unfathomably stupid, and one of which is misleading, let's say.
Okay, yeah. So first, the claim is that the final report is void ab initio or ultra virus. And, forgive my Latin. But basically it's, hey, Judge Cannon, you said special counsels were not legal, so because Jack Smith wasn't validly appointed, that means any funding he received is also not legal, and that means he can't spend any of that illegal money writing an illegal report. I mean, basically they say that Jack Smith is an unperson, his writings are an unreport, and, you can't transmit a thing that doesn't exist to Congress or otherwise make it public.
Right. That's a dumb argument. Even for Stan Woodward, Nauta's lawyer. He's lots of Trumpland's C and D listers lawyers. He represented Peter Navarro, Dan Scavino, Kash Patel, and several witnesses in both the special counsel investigations. And now he's going to go work at the White House in some job whose title I can't remember, but you and I get to pay his salary. Hooray.
All the best people. But yeah, and look, factually, the DOJ responded to that by saying, report's done and written, right? Like there's no more money to spend. Okay, so that was argument number 1. The second argument that the dipshits make is that releasing the report would violate the Presidential Transition Act and the Executive Vesting Clause. So they say, release will disrupt the president-elect's ability to govern once he takes office. That was the point you were making, right? Like, criticism equals treason. Mm-hmm. Like an indictment, the final report threatens public stigma and opprobrium, and so could compromise the president's ability to fulfill his constitutionally contemplated leadership role with respect to foreign and domestic affairs. I mean, basically, they say that it's illegal to say stuff that would make President-elect Trump look bad because that will impair his effectiveness, which is insane. But okay, even if we lived in a world in which that wasn't insane, 2 civilians don't have standing to make that argument, right? And the Presidential Transition Act doesn't provide for a cause of action anyway. It just says it is the intent of Congress that federal officers promote orderly transitions in the office of president. I mean, Trump has filed an amicus brief saying the same thing. It's just bonkers.
Yeah. And the third argument that the dipshits make is that their pending criminal case, the one whose dismissal is on appeal to the 11th Circuit, could be compromised if all of the details of the investigation were published in the special counsel's report. They said Special Counsel Smith, in defiance of this court's rulings, is determined to have the final word by pushing forward with issuing and transmitting a final report under 28 CFR Section 608C, which Attorney General Garland is certain to make immediately public. And, that is the least terrible argument, right? But it's misleading and it's functionally moot because, as Attorney General Garland said, both in his filings to the 11th Circuit and his letter to Congress, he's not going to publish that, right? And I think it's probably a lie. It seems to me that the special counsel has already given the defendants a redacted version of the document that removes the relevant information with regard to their pending case. So, fine. The DOJ says, all right, clearly we're not going to get anything from Aileen Cannon. So they go to the 11th Circuit and they file a brief that says there's absolutely no reason to issue an injunction here because we've agreed not to release Volume 2. And, the dipshits want you to restrain the special counsel from doing something, but the special counsel's done. Like Jack Smith handed in his homework, and what you really want is a restraint on the Attorney General. And there's nothing in the record that would support that. And then, after addressing some terrible arguments about the Presidential Transition Act and the executive vesting clause, the Justice Department made a really pointed request that the 11th Circuit not send this back to Cannon, which is what Trump and the dipshits have been asking for. The dipshits claim that this requires an evidentiary hearing to determine what can be included in the special counsel report. They said that, the trial judge has the right to control her own court.
There is no trial judge, right? This case was dismissed by Aileen Cannon at their request.
So the Justice Department said, to avoid the potential need for further emergency litigation in this court, the United States respectfully requests that this court make clear in denying the motion that its resolution of this question should be the last word, absent review by the en banc court or the Supreme Court. The United States respectfully requests that if this court agrees that no injunction against the Attorney General is warranted, the court should say so in an order binding on the district court and vacate the district court's temporary injunction.
Yeah, and then tonight, right as we were about to record, the 11th Circuit ruled, and here, I'll just read it in its entirety. Appellee's emergency motion for injunction with relief requested by January 10th, 2025 is denied, to the extent that appellant seeks relief from the district court's January 7th, 2025 order temporarily enjoining appellant may file a notice of appeal from that order. So, essentially, nobody gets any relief, right? Nauta and De Oliveira do not get an emergency motion with relief requested, and the DOJ doesn't get any relief from Aileen Cannon's injunction that she entered on Tuesday. What do you think, Liz?
Yeah, I mean, I really want to unpack that because it's not clear, and that is the worst part of this, right? It's an unsigned 2-sentence order issued with no, there's no reasoning, and basically what it says is we're not going to give Trump what he wants. He's not going to get to bottle up the report. But neither are we going to give the Justice Department clarity on what to do here. If you want us to take this back from Judge Aileen Cannon, who should arguably not have had it in the first place, you're going to have to, litigate with us some more. This is the exact scenario that the Justice Department was trying to prevent. And I don't know what the hell's going to happen. Nobody knows what the hell's going to happen. We're going to have more litigation. And I mean, I think this was always going to wind up at the Supreme Court. But now there's a lot more kind of tripwires for the government.
I think that's exactly right. So let's unpack. There's a lot in what you just said. Number one, there's a clock that's ticking here, right? There's 10 days until Donald Trump is the president and Merrick Garland is no longer the attorney general and will not have the authority to disseminate the report. That will devolve to Pam Bondi, who's a Trump lackey, right? We know what she's going to do with the report. So time is of the essence. The 11th Circuit knows time is of the essence. They ordered additional briefing, which they got. So, right, I mean, to the extent that appellant seeks relief, the appellant seeks relief, right? That's the DOJ. They told you they were seeking relief. They specifically said, get rid of Cannon's order, right? And so I am sure that as we are recording, that the DOJ is filing a notice of appeal from Aileen Cannon's order and is filing a motion for expedited consideration. And look, maybe the 11th Circuit will deal with all of that tomorrow, but maybe they'll stretch out briefing into next week, and who knows? And in the meantime, the injunction continues, and that's what Trump wants.
Yeah, I'm going to read to you what Trump posted on social media. Deranged Jack Smith was sent packing after losing both of his witch hunts against President Trump. Deranged was unconstitutionally appointed and paid for, so he cannot be allowed to do anything more in perpetuation of his election-interfering hoaxes, let alone prepare an unconstitutional, one-sided, falsehood-ridden screed. Today's decision by the 11th Circuit keeps Judge Cannon's injunction in place and prevents any report from being issued. It is time for Joe Biden and Merrick Garland to do the right thing and put a final stop to the political weaponization of our justice system. And
so they're taking a victory.
I know
lap.
that he's spinning. Yeah. Well, I mean, I don't know what's going to happen, except that I know that tomorrow Judge Cannon is going to say, okay, I'm in charge. I'm going to set a briefing schedule on this. You know, I'll set a normal briefing schedule. Like next week, DOJ, you can file your response. And the week after that, you know, Trump gets another response and then we'll have a hearing. And by then, I mean, what the 11th Circuit has done looks to me like they've punted it to Aileen Cannon without remanding it. I don't know. I don't know what's going to happen. But they could have put a stop to this rigmarole and they chose not to. And it sort of looks to me like they did that on purpose.
Yeah, I think that's exactly right. I think it also reverses the burden on the parties here, right? Because when you are the party affirmatively seeking injunctive relief, right, you have to show all of those standards. And so now the DOJ is going to have to say, hey, this has got to get resolved in the next 9 days. And why does this have to get resolved in the next 9 days? Because of what we all know is going to happen, which is that Trump is going to bury this. And that sort of puts them in tension with the argument they're making now, right? Like the argument they're making right now, which is true, is, look, we're all professionals here. We don't have an like we're going to abide by the law and you should trust us to abide by the law. And it's kind of hard to say the thing that they would like to say, which is, and the guys that are coming in after us aren't going to. That's a tough argument to make. So,
yeah, I'm not real hopeful about this. I mean, maybe the 11th Circuit will pull its shit together, but I think that Trump is going to look. What I thought was going to happen is that the 11th Circuit was going to say, no, Aileen Cannon, we're not going to enjoin this. And then Trump was going to race to the Supreme Court.
Yeah.
I'm not sure that there's going to be time for that.
I think I agree with you on both halves of that. I, too, thought they were going to smack down Judge Cannon, and they didn't. Now, I don't want to be too much hopium here. But I do want to give voice to the other side because the thing that you've said repeatedly that I want to emphasize is we do not know, right? We don't know what's happening. We don't know what their reasons are. We don't know what their motivations are. And one potentially salutary effect is that now this is not teed up for the Supreme Court to reach down and get its hands dirty. And so, maybe that will wind up being a better situation. Maybe there will be a time in which the 11th Circuit lifts the stay and then instantly Merrick Garland releases the report. Could do that. Another avenue is, as we've talked about in the past, the Mike Gravel route. That's the former Alaska congressman who read the Pentagon Papers into the congressional record as a way to get that in. And, it is immunized by speech or debate clause immunity. Jamie Raskin, the ranking minority member of the House Judiciary Committee, could certainly do that, right? Like there are ways to get this information out, but I thought there was going to be a clear path, and this does not offer clarity.
No. I'm sorry, guys. I'm really not hopeful on this one. All right. We are going to call it a day. We will be back on Tuesday with another show, back Monday with written content as always. And thank you. So many of you have joined in the past couple of weeks, and we really appreciate it. Couldn't do it without you. And we're all here. We're all in this together. Okay. Have a nice weekend.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Up to Media, LLC, all rights reserved.